我哋已經
Members, we have a quorum. I call the meeting to order. This is the Bills Committee on Courts Remote Hearing Bill. There is a list of follow-up actions arising from the meeting on the 10th of January. Is CB bracket 291 stroke 2025 bracket 01. And there is also another document from the administration. Is paper bracket 291 stroke 2025 of 03. Senior Assistant Legal Advisor's letter. The Judiciary has given us a response. Is CB bracket 291 of 2025 bracket 02. Now I ask Deputy Judiciary Administrator Planning and Development, Mr. Jose Yan. Mr. Yan, please. Good morning, everyone. As mentioned by the chairperson, we submitted a response last Friday to address issues raised. I'm using the Chinese version. On the first page, you'll find additional information on the appeal mechanism as requested. Paragraph 1 sets out that there is an opportunity for the parties to be heard as necessary. They may make representations to the court on the suitability of using the mode of remote hearing. The court will take their views into account before making a decision. Paragraph 2 sets out that the decision for the court to direct a remote hearing for proceeding is a case management decision. It sets out information about the existing appeal mechanism in relation to a decision of the court on case management. Aggrieved parties may lodge an appeal under the existing mechanism. I'm not going to go into details because practitioners are familiar with the mechanism. In paragraph 6, we emphasize that the case management decisions, that is, in relation to making, varying, and revocation of a remote hearing order, will see that existing rules and procedures continue to apply. Parties may lodge an appeal on these decisions, so there is no need to provide a separate appeal mechanism in this bill. The Senior Assistant Legal Advisor sent us a letter raising issues in relation to the legislative intent of Clause 14. There is no difference between a remote hearing and a physical hearing. The consequence of failure to attend a remote hearing is the same as those of a physical hearing. The court will take into account the role of the absent participant, whether it's a witness, a party to the proceeding, legal representatives. The court will also take into account the reasons for the absence and the nature of the proceedings and other circumstances. In a civil proceeding, if one fails to attend the hearing in a claim, then the claim may be struck out. If it's a witness that fails to attend a hearing in either a civil or criminal hearing, the person may be found to have disobeyed a court order and may be held in contempt of court. The court will take into account evidence and information before making an appropriate decision. Members, if you want to speak, please press the request to speak button. 4 minutes each. First, Mr. Lam Chun Sing. I would like to follow up on clause 14. Last time, Ms. Margaret Chan asked a similar question. Maggie Chan asked a similar question. If you are absent in a remote hearing or a physical hearing, the nature of the absence itself is the same. Ms. Chan set out a scenario that I think is plausible. A person knows that they're supposed to attend a remote hearing, but out of technical difficulties, the person fails to attend. It happens very often. In a virtual meeting, we are seen but not heard, or and because of technical or internet connection problems, we could not log in. And so the suggestion was that, well, if the person failed to attend because of technical reasons, perhaps a call can be made to the court to explain. And I wonder whether the court would accept that. I think it's about reasons that are out of the control of the participant. Perhaps in a physical setting, the person stuck in traffic because there was a serious congestion in the entire area. Perhaps in a similar situation, the reason can be accepted to explain away the absence. Of course, we don't want to see any abuses. Say a person is reluctant to attend, so the person blames the internet connection for their absence. If that is the case, how do you verify? Of course, we do think that a remote court hearing is still a proper proceedings, so you will have to attend. Who makes the decision? Is it the court? Are there any criteria for the court to take into consideration? Mr. Yan, thank you for the question. As I said, the nature of a remote hearing is the same as that of a physical hearing. Absence, failure to attend will bring the same consequence. There may be different scenarios. The court will take into account the reason for the absence, the nature of the proceedings, relevant circumstances of the case before deciding the consequence of the failure to attend. It is difficult to comment on what will happen on individual cases. Well, the court will make a suitable decision taking into account relevant factors. Mr. Lai Tong Kwok. Thank you. Failure to attend a remote court hearing, is it contempt of court? If that is the case, is it criminal in nature? If that is the case, does it require, is mens rea required? There is an example in the paper. If a witness fails to attend a hearing in answer to a witness summons, then the person may be found to have disobeyed a court order and be held in contempt of court is criminal. If that is the case, what is the mens rea? We consider the case as a whole. A witness received a witness summons to attend a hearing. If the court is of the view that the witness fails to attend without a justifiable reason, the court will make a suitable decision. Let's leave it to the court. I'd like to follow up on this as well. There is a legal term, force majeure. Mr. Lam said that talked about a scenario when there is a serious pipe burst or there was a traffic accident that have stopped the person from attending. The court will take that into account. Very often, members of the public may misunderstand the nature of a remote hearing, thinking that it's not as serious as a physical one, but the nature, the spirit are exactly the same. I think you need to explain it very clearly to the public. When someone receives a summons, I think whether the person managed to attend or not is a very specific issue that can be decided after taking into account relevant factors. We have completed that part. Last time we completed clause 14. I invite members to start with clause 15, that is C2458 for the Chinese version. We will continue from there. Members, if you would like to ask questions, please press the request to speak button after the administration and the judiciary have gone through the clause. Now, clause 15, Mr. Yam. Clause 15, attendance at remote hearing deemed to be physical presence. A participant who attends a remote hearing through a remote medium in compliance with a remote hearing order is deemed, for all effects and purposes, to have satisfied the requirement under any law or an order or direction of the court to be physically present at the proceeding. In short, as it was mentioned, a remote hearing is as solemn as a physical hearing. It's the same. They are the same. Mr. Orinkong. I have some questions on drafting. Line 3 in English version. For all effects and purposes. Can I hear from colleagues from drafting? Very often you find this phrase in the law, all effects and purposes. What does it mean? Thank you. I think we need to refer to the instructions received. When it comes to court proceedings, there are many pieces of legislation. The statement, the effects are different depending on the provision, but we don't want to change the existing principle. That is, the rules of the game of a physical hearing. Under this framework, in the deeming provision, we set out the purpose very clearly. So for whatever reason, for whatever effects, if it's a requirement for the participant to be present, the effect is the same in a remote hearing. So we have considered the policy direction and And the style of drafting in this exercise, we have chosen this phrase to make it more concrete. Members of the public need to know exactly what they need to do to act in accordance with the law. That's why we've added this phrase. This is to allay the concern of the public. You just attend the hearing at the time, date, and the virtual venue, then you are deemed to have been present. So that's why we've added this.
江議員。
Chair, Ms. Doreen Kong. Let me say something as a legal practitioner myself. Drafting legislation is different from writing a novel. So when I read this, I was confused. It seemed almost like I haven't read the law for a while. I've rarely saw for all effects and purposes. Shouldn't you just spell it out? In English, well, actually saw for all intent and purposes, that is in effect. So I thought it might have been wrong when I read it yesterday. I tried to do some research whether it is included in legislation elsewhere, but I haven't found this elsewhere either for all effects and purposes. I think you should just spell out the effects and purposes. If you don't spell them out, if you just say for all effects and purposes. In fact, if you look at section 19, this is a problem in 19.2 for the provision. After saying for all effects and purposes, you say for the purposes of a physical hearing. So how many purposes are there really? Chair, let me say this. As Mr. Lai said, this expression is essentially unnecessary. Wouldn't that really hurt one's interpretation of the provision? I urge the administration to review whether this part is indeed necessary. I would like to add something. Chair, sure. Mr. Lai asked if contempt of court was a criminal offense. I urge again the administration and the Judiciary Administration to review that and give us a reply after a meeting. Contempt of court may be criminal or it may not be criminal. It is about one not fulfilling their responsibility to attend court. So it may not be criminal in nature. Excuse me, I was late, so I just did a quick reading on this. I just want the administration and Judiciary Administration to give us a reply after reviewing the circumstances and the provisions. Thank you. Administration or Judiciary Administration, thank you. We thank Ms. Doreen Kong for her suggestion. We will review that, and if necessary, we'll provide a reply to the Bills Committee in due course. Ms. Kwok Kwok, are you of the same view? Indeed, Chair. All right, so they will review the issue. Ms. Doreen Kong, any follow-up questions? If not, we'll move on to Clause 16. Mr. Jose Yam. Thank you. Clause 16. Law enforced in Hong Kong applies to participants outside Hong Kong. The law enforced in Hong Kong relating to evidence, procedure, contempt of court, and perjury applies to a participant who attends a remote hearing in compliance with a remote hearing order at a place outside Hong Kong. Yes? Okay. Mr. Lai Tong Kwok. I would like to follow up on what Ms. Doreen Kong said about for all effects and purposes. Honestly, I think clauses 15 and 16 work almost essentially the same. But for all effects and purposes, this expression was not found in clause 16. So I would support the approach suggested by Ms. Doreen Kong, that the administration should review this. Thank you. Any other questions from members? If not, we'll move on to Clause 17. Thank you. Clause 17, administration of oaths and affirmations. An oath to be sworn or an affirmation to be made by a participant in a remote hearing may be administered A. by way of a live audio visual link as nearly as practicable in the same way as oaths or affirmations are physically administered in a court, or B. by a person authorized by the court acting at the direction of and on behalf of the court at the place where the participant is to attend the proceeding. Yes. We have two members who have indicated their intention to speak. Mr. Holden Chow. I want to ask something. We are to also administer oaths or affirmations at remote hearings. We have many different written affirmations that would still require someone to attend an office to make such. So I want to ask if the judiciary has considered that since we already are administering oaths and affirmations online or remotely, would it be possible to administer oaths and administrations outside of proceedings remotely in future? I remember specifically during the COVID pandemic, there were some issues with not being able to administer oaths or affirmations remotely. So I want to ask if the judiciary has considered applying this to other scenarios or use cases. Thank you. Mr. Jose Yam. Thank you. When we're talking about administering oaths or affirmations here specifically, it applies only to proceedings. Oaths or affirmations may take place for different occasions, say for certain official swearing in or for works projects. As for other use cases of the government, I think we should leave it to the government to decide whether to administer such oaths or affirmations remotely. Mr. Lai Tong Kwok. When they talk about here is nearly as practicable in the same way, I want to ask why they thought this was necessary in the provisions. If you think oaths or affirmations have to be administered in a certain way, why not just follow that? And if you're talking about, say, in B, you have a person authorized by the court, it's not that you are having affirmations or oaths administered by court clerks like physical hearings. You already provided for something different here. So why is it that you put the expression specifically that it should be as nearly as practicable in the same way? Thank you. Deputy Judiciary Administrator. Thank you. Well, for the situation, we would have judges and court clerks physically in court, and we would have the participant or witness giving evidence remotely. And for Clause 17A, that would apply in this scenario. And when one is taking an oath or affirmation, they should take so in accordance with the law of Hong Kong. The manner is, of course, essentially the same as what is done in court. But, after all, this is done remotely. This is done through maybe an online system. Say for a live audio visual link, it may be done via video. So we want to say in a general manner that it would just be as nearly as practicable in the same way. Mr. Lai. I just think this expression is unnecessary, and having added this, I think it would cause a misunderstanding, or there may be unintended consequences. You do not define what as nearly as practicable in the same way is. If you just say it is in the same manner, it would be quite clear. When you're saying that as nearly as practicable in the same way, I think there can be confusion. There may be uncertainties. I don't see for a witness giving evidence remotely why it is not possible for them to follow the procedures of having oaths and affirmations administered in courts. Just follow the procedures. I'm just confused why they can't just do that. Deputy Judiciary Administrator, or is it the Senior Assistant Law Draftsman who will answer the question? All right, Ms. Carmen Kwok. Thank you, Mr. Lai, for your concern. Let me share with you some background information on this provision. We already have some witnesses giving evidence overseas, and for 79K, we actually have the same provision or a similar provision for overseas witnesses. Of course, we have our own rules, but there may be other rules in overseas courts as well. So we have to allow some flexibility for the judiciary's operations. If we only say that we need to follow the rules of the Hong Kong courts, it may not offer flexibility. So acting on instructions given by the judiciary, we just want to follow what we have right now. That is the approach that is being taken by the judiciary at the moment for overseas witnesses giving evidence. So I'll perhaps let the Deputy Judiciary Administrator supplement answers. Yes, Mr. Yang. Indeed, we are adopting a similar approach for witnesses taking oaths or affirmations in court. They would have a court clerk assisting them in taking such oaths or affirmations. But with, say, overseas witnesses or some witnesses in Hong Kong giving evidence remotely, court clerks are not in the vicinity of the witnesses. So maybe one can say that it is as nearly as practicable in the same way, not exactly the same way. So I think it is essentially we are taking the same approach. We just want to say that the power given by the oaths and affirmations are the same. The mode may just be slightly different. Mr. Inca, I think we should ponder over this. We have the Oaths and Declarations Ordinance, that is Chapter 11. It spells out how we should have oaths or affirmations administered. And the law draftsman mentioned Chapter 221, that is Criminal Procedure Ordinance, Section 79K. I actually have no problem with Clause 17B. With 17A, however, we say specifically it should be as nearly as practicable in the same way, and this would apply to cases where a live audio-visual link is used. I think the way they drafted it essentially changed the Oaths and Declarations Ordinance. I think this is a dangerous thing to do. When we're talking about oaths or affirmations, the taking of which is actually very important because it is important in the sense that it would verify the integrity of the witnesses to make sure they are telling the truth. I just want to do it in a way that won't hurt the operations of Oaths and Declarations Ordinance. And in fact, in Singapore, they have a Remote Methods Act for the taking of oaths and declarations, or oaths or declarations or affirmations. The Act spells out specifically how to deal with the administering of oaths or administrations. In Schedule 3, they talked about specifically 2 ways that would amend their oaths and declarations ordinance in their region. That is when using live television link or live audio link. But it is the case that we do not have specific alternatives for that, the taking of oaths and affirmations in Singapore. So I urge the administration and Judiciary Administration to really review whether this approach should be taken. Thank you.
多謝
Mr. Yan, thank you. It's not like we don't have any plans to amend the legislation on oaths and declarations. We will review the wordings to see if we can improve, if there is any room for improvement. Next, Ms. Maggie Chan. I would like to also follow up on what other members have said. The law draftsman and the Deputy Judiciary Administrator talked about clauses 16 and 17. They said that the law applies to those outside Hong Kong. That is clause 16. Clause 17 is about oaths and affirmations. It says it's as nearly as practicable. My view echoes that of Ms. Kong. But I'd like to look deeper. We need to be very careful when it comes to 17A. I agree that it seems like it has changed Cap 11, that is, Oaths and Declarations Ordinance. Section 5 of Cap 11. It uses the word shall. That when it comes to an oath, the person taking the oath shall hold the New Testament, or in the case of a Jew, the Old Testament, in his uplifted hand. If it's done online, the person does not have the Bible with them. What happens? Under Section 5 of Cap 11, it says that the person shall hold the New Testament or the Old Testament. In a bill 17A, it says as nearly as practicable in the same way. You want to cover that as well? If there is no Bible, the person is allowed to have deemed to have made the oath. If that is the case, you have to address the discrepancy between 16 and 17. you also need to address the issue of 17A as nearly as practicable in the same way. In English, it's nearly. I've been a lawyer for over 30 years. I don't think I've come across this term, this word. It strikes me that there is huge uncertainty with the use of this word. And that's where dispute arises. In criminal cases, we see as reasonably as practicable. I'm not saying that that has to be used. But you do need to address the issues of clauses 16 and 17, as well as Section 5 of Cap 11. Mr. Yan. Thank you. There are two types of there are two types, oaths and affirmations. If someone takes the oath, then the person will use the Bible or any religious publications. It's set out clearly in the law. So in different scenarios, the witness may use the suitable way to take the oath. The oath itself is solemn and serious. I hear Ms. Chan's concern in terms of wording. We will go back to review the wording to see if there is any room for improvement. Ms. Chan would like to say something? Yes. I have a suggestion. Well, since it's done online, perhaps an innovative way can be used. Say, for example, ask the clerk in the court to lift up the Bible, and then the person online will raise his hand as if their hand is on the Bible. Can we deal with it in this way? Because there are many different scenarios. I've heard the members' view. I'll follow up on the same issue. When it comes to oaths and declarations ordinance, as members in the large term of the legislature know that there can be a lot of disputes. I will suggest a direction to see if it helps. Can you break it down to get to 3 parts? There is a C that you include an approval by the court in terms of the manner. Ms. Chan talked about an innovative way for someone to take an oath. But for someone who is religious, that manner may not be acceptable at all. The person may oppose to the lifting of the Bible, which is very important to someone who is religious. Perhaps we'll leave the decision to the court. If you differentiate the scenario that is within Hong Kong and outside Hong Kong, perhaps there is a way to address it. That's my suggestion. Thank you. Of course, we will go back to carefully consider it. If a witness attends a court proceeding remotely, there will be in advance proper arrangements made, time, place, the manner of the manner of taking the oath or affirmation. A reminder will be given to the witness to bring the religious literature required. The arrangements will be meticulous. A witness, whether within or outside Hong Kong, in attendance of proceedings, will go through the same procedure. This will make things simple. It will make it easier for the participant to know what the procedure is. In any event, we will go back to reconsider the wordings of Clause 17. Ms. Doreen Kong. A suggestion. In the UK, when it comes to remote hearing, there is a dedicated link. The courts will provide huge assistance, say, making the religious literature available. There are facilities in place. A link is provided for the wording. There are dedicated links for everything. When it comes to the actual operational details, they can be set out in the practice direction. I see that in some jurisdictions, a lot of importance is attached to the administration of oaths and affirmations. Please consider it. Any other questions in relation to this clause? I believe that Mr. Yam will consider members' views. Now, Clause 18. Division 3. Transmission of documents, presentation of objects, etc. in remote hearing. Clause 18. Interpretation and application. 1. In this division, document means anything in and on which information of any description is recorded. Object means anything other than a document, which may be in tangible or intangible form. Send, in relation to a document, includes file, lodge, produce, give, notify, serve, deliver, submit, furnish, and any other expression that signifies or suggests conveying the document. 2. Nothing in this division affects the operation of A. The Electronic Transactions Ordinance Cap 553, or B. The Court Proceedings Electronic Technology Ordinance Cap 638. Cap 638 is under the Integrated Court Management System. The Case Management System. This is the piece of legislation on which the system is based. Any questions? No? Please continue. Clause 19. Transmission of documents. 1. A document in relation to a remote hearing may be transmitted electronically as directed by the court. 2. Where a document is transmitted in compliance with the direction under subsection 1, the transmission is deemed for all effects and purposes to have satisfied the requirement under any law to send such a document for the purposes of a physical hearing. In short, we're going to have remote hearing, so a lot of the procedures will be done electronically. Say, for example, submission of a document electronically to the court. The submission is deemed the same as the submission of a document in the physical hearing.
Ms. Doreen Kong. Chair, thank you. I would urge the Judiciary Administration to review the use of the expression for all effects and purposes. I also want to ask about a Chinese text of Clause 19.2. So in the second line of the Chinese text of 19.2, it seems that a particular punctuation is used that would signify a pause. So, is that punctuation really necessary? Why not just combine the two parts? Why is this punctuation used? I think it can just be a single part here, so that the whole sentence would read, to have satisfied the requirement under any law to send such a document for the purposes of a physical hearing. And honestly, even if a punctuation has to be used, it should be a comma instead of this punctuation here. Thank you. Mr. Jose Yam, we do note Ms. Doreen Kong's concern on the use of for all effects and purposes, and I'll let Ms. Kwok answer the drafting question. Oh, is it another colleague who will answer this question? Mr. Vincent Y. Thank you. With the use of this particular punctuation in Chinese, for modifiers that are relatively long, it will be the case that we would use this Chinese punctuation in between the different modifiers essentially. So basically, we would say one part would be under any law, and then the other part would be for the purposes of a physical hearing. So this is also commonly found in other legislation when the modifier is relatively long and has different parts. We would use this Chinese punctuation in such cases. I hope this explains why we use this punctuation. Thank you, Ms. Doreen Kong. Any follow-up questions? Chair, excuse me. I am not that good in Chinese. I would just urge the Judiciary Administration and Administration to review this. I am not trying to argue for anything. I just want them to review if this is really necessary. Alright, please review the usage so as to allay the concerns of the member. Mr. Porter, I think if there is something different here, it is appropriate to use the Chinese punctuation, but then in the English version, it seems to be one connected part. I would just urge also the Administration and Judiciary Administration to review whether this punctuation is really necessary, because it would break up the part, and I think there is no need to use that many other parts or prepositions to say that because it would really break things up in Chinese. Mr. Jose Yam. We do note there are some rules and conventions with drafting. We'll review this to see if there's any room for improvement. Mr. Y, anything to add? We do note the members' suggestions. We will review this. Let me say something before. When we were drafting Chinese legislation, they are often just literally translating English. And I think you can review other legislation to see if the usage is appropriate here. Are we supposed to move on to clause 22, or is it, clause 20? Please. Thank you. Thank you, Chair. 20. Presentation of objects. An object in relation to a remote hearing may be presented electronically as directed by the court. Yes, Ms. Doreen Kong. Thank you, Chair. I want to ask, so with the presentation of objects, there can be different objects. Is it possible to include different manners of presentation? in clause 20. I understand the remote hearing part, but then the objects may be located at different places. So is it possible to include or accommodate different ways of presentation of objects in clause 20? Mr. Yam. I know many members have visited the district court building. With the presentation of objects, there are different manners of presentation. If we are playing a video or an audio clip, it may be played on a computer. For physical objects, it may be displayed on a projector. There are many ways to present an evidence. Before the commencement of the hearing, I believe parties would agree on the manner of presentation of objects, and the objects will be submitted to the court beforehand if necessary, and the court may present such objects for the parties' reference. Thank you. Moving on to clause 21. Signing or writing on documents. 1. If a participant to a remote hearing is required to sign or write on a document under any law or an order or direction of the court may, for the purposes of the requirement, request that the participant sign or write on the document in a way as directed by the court. 2. Where a document is signed or written on in compliance with a request under subsection 1, the signature or writing is deemed for all effects and purposes to have satisfied the requirement to sign or write on the document for the purposes of a physical hearing. 3. In this section, write in relation to a document includes draw, shade, color, circle, cross out, underline, highlight, annotate, and any other expression that signifies or suggests marking on the document. Thank you, Chair. Mr. Paul there. Excuse me, Chair. I actually had a follow-up question for clause 20. I'm not an expert in the use of Chinese, but the Chinese translation almost sounds like an AI translation. The meaning in the English text is clear. That is an object in relation to a remote hearing. But then in Chinese, it is almost like they have switched the subject and the object. So here they say in Chinese any objects in relation to a remote hearing. I think it is somewhat confusing. It shows that there are problems with the Chinese translation. Since we are scrutinizing legislation here, I think we should really review that to make sure it actually sounds like Chinese. Thank you. Mr. Y or Ms. Kwok? Ms. Kwok. We do note Mr. Zhe's concerns. We will review the Chinese translation. Thank you. Ms. Doreen Kong. Thank you, Chair. I want to point out something. Again, I would urge the Judiciary Administration to review 21.2, the use of the expressions for all effects and purposes and for the purposes of a physical hearing. And again, there is a translation issue. It says here in the English text, highlight, and in the Chinese text, it's galang. It's almost like they are trying to brighten something. That is the meaning. There are different ways to express the meaning of highlight instead of using this Chinese expression basically to brighten something. Also, many elderly persons would use a stamp to sign something. So I want to ask, would the definition of right here accommodate this scenario? Thank you. Mr. Jose Yam. Thank you, Ms. Doreen Kong, for your suggestions and questions. We note your suggestions. We will review the use of relevant expressions. And let me say this, because in clause 18 we did say nothing in this division would affect the operation of the electronic transactions ordinance. So first of all, electronic signatures would not be affected. It would be accepted. So say in chapter 553 there are electronic signatures. So for one to sign on a tablet or using a sensor pen to sign on a tablet or a panel, that would accommodate the scenarios of elderly persons essentially putting a cross or just scribbling something on the panel or the screen. And in proceedings, often signatures would be required, or the filling out of some papers perhaps after the proceedings. On certain occasions, one may have to sign some papers. Some examples would be some summary of bail records. So this approach has already been taken for the signing of such documents. Thank you. On the member's question on translation, I understand what the administration and Judiciary Administration said. We have, however, seen this issue arise time and time again. I believe when we dealt with the matrimonial law bill, we had raised some similar issue, and concerns were expressed by members. I would urge you to review whether this translation of highlight is new or if you have used this translation before. I do understand that you would try to be consistent if you have used this expression before, but I think there is a time when you really have to think about changing the way that you have been doing it. And between 1991 and 1997, I was on the Black Committee, the Bilingual Law Committee. We had already had lively discussions on the translation, and we had reviewed legislation elsewhere, perhaps legislation in Taiwan, to see how we can better translate the laws in Chinese. If we only adopted the Chinese translation literally, it would be confusing because it is not easy to read at all. And we now have an improvement, but I guess it is always prudent to review translations that do not really sound natural. We have two English expressions used for the same Chinese expression, and I think these are probably due to different translators using different expressions. Can we adopt a consistent translation? It's just like with the adaptation of laws. There is always a first step to take. And this is a persistent issue that we really need to tackle at some point, and I think it is my responsibility to point out how things have developed. And perhaps we should start somewhere with a single piece of legislation to make the Chinese sound more natural. Of course, it is a huge project to undertake. Let me just put this out there for reference. Thank you.
If there are no more views on this? Mr. Yan, please. Part 4, public access to open proceeding. Clause 22, meaning of open proceeding. In this part, open proceeding means a remote hearing that is not to be held in private. Yes. No comments? Let's move on to Clause 23, direction for public access. The court must, in relation to an open proceeding, give direction to allow access to the proceeding by the public unless the court, for any of the reasons stated in Article 10 of the Hong Kong Bill of Rights set out in Part 2 of the Hong Kong Bill of Rights Ordinance Cap 383, otherwise directs. The legal advisor, in relation to the English version, gave a suggestion on the heading by adding public access to open proceeding. We have taken that into account. We will move a CSA in this regard. Any questions from members? If not, let's continue. Clause 24, broadcast of open proceeding. 1. The court may cause an open proceeding to be broadcast. 2. A broadcast of an open proceeding must be accessible by the public, A, in a place and in a manner as specified by the Judiciary Administrator, or B, through such other means as the court considers appropriate. When we explain the policy, we have gone into detail in our explanation to the practice when an open proceeding is broadcast. It will be broadcast in the lobby, but under special circumstances. Say, for example, during an epidemic when the court back in those days was closed, it was handled in a different way. The word cause in English, in Chinese is 安排廣播. Do you adopt the same practice in other places? We think that in this area, the word itself is appropriate because cause is to make it happen. It's not for the court to make arrangements to make it happen. That's why we use the word cause. Just now you use the word to procure for it to happen or make it happen. So if you use a different word, will it be different? I just want to know the rationale behind your choice of word. The instruction we receive is that the court may have a broadcast of an open proceeding when the situation is suitable. That's why we use the word cause. In relation to the detailed arrangements, there are other provisions for the court to make the arrangements. Then we'll go back to look at why we use this word. Yeah, use a simpler word. The English phrase must be accessible. It's easy to understand, but in Chinese is 觀聽讓公眾能觀聽. So is it a suitable word, Mr. Y? We have chosen the word in Chinese 觀聽 to listen and to hear. So it can be an audio-visual link or just an audio link. So for audio-visual link, we're talking about a person being able to see and listen. So for the word gun is in relation to visual, ting, and then it corresponds with the word audio, to listen. That's why we have used this term gun ting, see and listen, to explain to correspond with the same term in English. I think there is a minor difference. You have added the interpretation of accessible to the word gunting, to watch and listen. But it's a broadcast that the person has access to. So how can you make it more precise? Because these are easily comprehensible words by the public. I said that the word course does not correspond to ngon pai. Perhaps you can use the word to make arrangements. I seem to remember that there are terms that have been used before, but this time round you have added your understanding and interpretation into the word. So I asked you to go back and consider it further. Ms. Kwok? Of course, we have to take into account precision. We need to take into consideration the style, the flow of Chinese and English. Accessible in the common law jurisdiction, when you hear the word access, you understand. But in the Chinese world, we have tried a number of words corresponding to that, but they are not ideal. If we can't find an ideal equivalent, perhaps we will take the meaning and translate the meaning. We will go back to consider it further. I think if we take the meaning, it will be easier for the public to understand. It's very easy for us to find the equivalent of the word access. But members of the public may not understand what it means by the Chinese equivalent. We want to take the meaning to make it easier for the public to understand. The general public usually refers to the Chinese version. So very often we may lean towards using the translation of the meaning. Well, it's very clear in Chinese. Perhaps in English you can add a little bit more to make it the same as English. That is, if you read the English version, you will immediately understand what it means. Perhaps members can make suggestions as well. Ms. Eunice Young, I would like to ask about Clause 24(2)(a). I think it's quite verbose in the Chinese version. In English, it's in a place and in a manner as specified by the Judiciary Administrator. In Chinese, there is a repetition of the Chinese term of Judiciary Administrator. I think you can simply remove the second reference of Judiciary Administrator in the Chinese version to make it more simple. This is an example that there is a difference in sentence structure in Chinese and English. Sometimes it's necessary to repeat the subject or the object. In English, in a place and in a manner as specified by the Judiciary Administrator. In Chinese, it refers to a place specified by the Judiciary Administrator, and in a manner specified by Judiciary Administrator, then Chinese will have to change the sentence structure. To be precise, in Chinese, we need to repeat Judiciary Administrator in the Chinese version. I don't think the answer answers my question. I don't see the difference. A place and manner specified. You mean the place specified includes the manner and the manner specified includes the place? I want to know why you phrase it in this way. We want to include place and manner. That's why we use the connective "and" in English. In Chinese, we want to say that both are included. And that's the flow of Chinese. I think it's a bit stretch in your explanation. Perhaps, you explain to us what the difference is. Can I use the word cup and to link the two? And if you need to separate the two, what are the differences? I think it's something to do with the legal translation. I'm in charge of these projects for many years. In English, you use in a place, in a manner. In Chinese, when it comes to a place, you use a different preposition. When it comes to manner, you have to use a different preposition from place. That's my understanding. In English, you can group them together, but you can't do that in Chinese because of the difference of prepositions involved. Is my understanding correct? Yes. Yes. Is the preposition used in Chinese when it comes to the word place and manner. We can't use the same preposition for place and manner in Chinese. That's why we have to break it up. And in the Chinese structure, you need to repeat the subject, Judiciary Administrator in this case, to make the flow smooth. That's why, Mr. Ring Kong. Under Part 4, Public Access to Open Proceeding. Does it cover hybrid proceedings? That is, a proceeding involving virtual attendance and physical attendance? So does it include hybrid proceeding? Simple answer, yes. Legal advisor. Under Clause 22, open proceeding means a remote hearing. So it's in relation to the remote hearing in a proceeding. Just now, Ms. Kong asked whether it covers a hybrid proceeding. And 22 refers to a remote hearing that is not to be held in private. Can we clarify, please? You are lawyers. You're both lawyers. Or perhaps we will hear from Mr. Yam. In a remote hearing, there are participants, perhaps a judge, clerk, or lawyers who attend physically. So that is in relation to the physical part. A witness may attend remotely. The witness may be in Hong Kong or outside Hong Kong. I think it comes down to the situation. Sometimes it's hybrid. That's what I was saying.
嘅。多謝主席。
Mr. In Kong. I think a problem arises from this. I do thank the senior legal advisor for pointing out the issue with Clause 22. In the UK, they had issues with hybrid hearings for witnesses outside their jurisdiction. If they wanted to watch the broadcast at first during the COVID pandemic, they couldn't. That's why the UK amended legislation affording the public access rights, and the public meaning that would include participants when there are remote hearings, whether it's the physical part or the remote part of the hearing that would be broadcast, because for witnesses outside the jurisdiction, they would still want to watch the other parts. And UK legislation had been amended specifically to accommodate hybrid hearings. Thank you. Deputy Judiciary Administrator. When we explained our policy intent, we actually touched on this issue. In general, for court proceedings, they are not meant to be broadcast in the sense that anyone with an internet browser can access the proceedings. We spelled it out very clearly for the general public who would like to view the hearing. Whether the hearing is a remote one should attend the hearing in person, and it may be broadcast in the court premises via live television link in another courtroom or in the lobby of the court building. If for some reason the courts are closed, everyone is unable to go to court in person, under such circumstances, if members of the public wish to view a court hearing, they would have to apply or register with the court, and then the court would give them some login credentials, including a password for one to access the proceedings online. This is our policy intent. Thank you. Do members have any other follow-up questions? Right, Mr. In Kong. Excuse me. I just want to clarify something. So, say we have a court case proceeding. It may be a complex case, a commercial case with many parties, many witnesses. And if we are taking evidence from an overseas witness, and some cases can go for long, say a month, but then only 18 months would be a physical hearing and 12 days would be a remote hearing. If you are broadcasting the proceedings, for those outside Hong Kong, they can still view or listen to it. So will you be broadcasting, say, the 12 days, or would you be broadcasting proceedings for all of 30 days for this example? Mr. Yam. When the court decides on the arrangements, they would have reference to the nature of the case and whether the relevant witnesses would have the need to access the proceedings remotely for all of 30 days, and the court would make relevant arrangements. Let me say again, the proceedings are not meant to be broadcast for the public. And in general, we do not expect the general public, even if they are overseas, to view a public broadcast, and the Court of Final Appeal broadcasted on a trial basis their proceedings 4 times last year. But that is just on a trial basis. Say if a witness only attends the hearing on day 15, some relevant arrangements may be made for that day. For the other days, it would have to be with reference to the circumstances of the case. Thank you. Any other questions from members? Excuse me, Chair, can I raise further questions? Deputy Chairman. Excuse me, the Deputy Judiciary Administrator's response is not very clear. You are saying that the broadcast is not supposed to be public, but you are saying here it is an open proceeding to be broadcast. So with the hybrid hearings, I would say not only the witnesses would want to access proceedings if it is a party to the proceedings. According to the Deputy Judiciary Administrator, that person may not be able to view the entire proceedings. So how can the party follow the proceedings all along? They are not a witness. Now, we are trying to encourage the use of remote hearings to provide convenience. But if we have unclear provisions that may not accommodate hybrid hearings, and hybrid hearings are quite common, and it is clear that for a certain part it may not be physical. What is going to happen? I think the Deputy Judiciary Administrator's response is not quite clear. Can they provide a written reply after the meeting? Mr. Yam, I think I can perhaps try to give an oral reply now. If not, if the member is not satisfied with the reply, we will provide a written reply after the meeting. Now, for open proceedings meaning it is open as in the judicial process should be open. But for members of the public wanting to view the hearings, they should and they must attend court premises. Either they will be in the courtroom viewing the hearing, or they may be in the lobbies of courts watching the broadcast of the proceedings. We do note the views of the member, and some witnesses attend court via remote link. For witnesses, when they give evidence, they should talk about the things they are supposed to talk about. And relevant arrangements may be made for the giving of the evidence by the witness remotely. And the court may decide on whether there is a need for the witness to access the proceedings at other times. And like I said earlier, the court would make a decision with reference to the circumstances of the case. That is the approach to be taken. If this is unclear to the member, we can perhaps provide a written reply after the meeting. Ms. Doreen Kong, do you have any follow-up questions? Otherwise, the Administration and Judiciary Administration have expressed their views, and if there's any review in need, they will do that. All right, moving on to Part 5. Thank you, Chair. Part 5, Offences and Penalties. Clause 25. Interpretation for Part 5. In this part, first for record, A means any act of creating or generating an image or 2, any act of creating or generating an audio record, and B, includes any act of making an audio record, a visual record, or an audio visual record that is transmitted in real time with or without retention or storage in 1, a physical form, or 2, an electronic form from which the record is capable of being reproduced with or without the aid of any device. Alright, the next definition is the one for publish. It includes send, transmit, distribute, circulate, upload, reproduce, make available, and disseminate. And then it's the definition for image. Image means A, a portrait, drawing, or sketch, B, a photograph, video, recording, or film, or C, a static or moving visual record. Thank you, Chair. Mr. Lai Tong-kwok. Thank you, Chair. I note that in the English text for the definition of record or record, there will be different meanings. So in the Chinese text, you have used both record in verb form and record in the noun form. So in the definition of record, you actually use the verb form. So it can be for record or record, it can be either in verb form or the noun form. So we have record and record in noun and verb. And for the noun record, you would use a specific word in Chinese text, and in the Chinese text you can make the distinction between the verb form and the noun form with different characters. So have you considered how, with using both the noun and the verb form in the definition of record in Chinese with the different characters, it can cause some confusion? Mr. Y. Thank you, Mr. Lai, for providing your observations. So, for record in noun form in Chinese, we would use a particular radical, and the verb form we would use another radical. So that would differentiate record and record in noun and verb form in Chinese. So in the newer legislation, we have adopted this approach. Thank you. Thank you. Mr. In Kong. I have 2 questions. One is on the Chinese text. For the definition of publish, there are different meanings. So one would be disseminate, and the Chinese is 传播, and that is the first time that I heard this Chinese expression. I want to ask if this Chinese expression has been used before. Has this expression been used elsewhere even? So I also want to ask about 25B2. It says an electronic form from which the record is capable of being reproduced with or without the aid of any device. I think the way they drafted it is quite interesting. Can you give some examples where you would need the aid of a device and where you would go without the aid of any device? Can you give some examples?
Mr. Yam, I will first answer question 2. Perhaps the Lord Draftsman or Mr. Y will answer questions relating to publish. Here we're talking about an electronic form from which the record is capable of being reproduced with or without the aid of any device. and it refers to transmission in real time, that is, streaming. When it comes to transmission in real time, there is no recording involved. An electronic device is used to transmit the file to the internet. I will now defer to my colleague, Mr. Wai. The use of disseminate is used in other ordinances as well. Say CAPS 621, Section 78, sale of first-hand property, that is dissemination of false or misleading information. That's one of the examples. If necessary, we can supplement the use of this word in other legislation. Just now, Mr. Lai Tong Kwok gave me some information. Well, disseminate, in Chinese it can be 傳播、散發、發布、分發、提供及傳播, the different forms. But we're talking about an offense here. It's not simply a direct translation from English to Chinese. You have to let the public know when it comes to an offense. So what is the difference between the different Chinese terms? Why did you not choose one over the other when it comes to dissemination? And you have not explained to me as to what circumstance would involve without the aid of any device. You gave me an example, live streaming, but there is a device involved. You need to use a computer or on my mobile phone. So when will you reproduce something without the aid of a device? We're talking about the storage or record, retention or storage. In live streaming, there is no device used to retain or store the record. That's what I was talking about. Perhaps I'll defer to the law draftsman in relation to the wording. Mr. Y. The word publish. The definition is not an exhaustive one. We want to include the different forms that are similar. Say, send, transmit, distribute. These acts are covered under the same umbrella, namely publish. The member refers to the word disseminate. In Chinese, 傳播, it covers the meaning of send, transmit, circulate. What we're trying to achieve is to include a verb that is general, that covers different acts. Now it's my turn. I'll ask the Law Drafting Division to give it another thought. The Chinese word 傳播, in English, disseminate. Well, we don't see that very often. Are there any other examples that you use different Chinese words to make it easier for the public to understand the word disseminate? We're very used to having a word-for-word translation. For one term, there is another term in translation for that. But perhaps we should think outside the box by using a different way to translate the spirit of the sentence. And I think when it comes to this provision, it's likely that the public may refer to it quite often. Mr. Y? When it comes to defined terms, in English it may just be one word. If necessary, in the Chinese version, if we think that there is a need to use more than one term, we may do so. The definition publish. It covers different acts. Send, transmit. These are similar terms. We use the terms in existence that are commonly used. 送交傳送分發傳閱上載複製提供傳播 in English send transmit distribute circulate upload reproduce make available and disseminate. We think there is no need to elaborate the word disseminate with more Chinese terms. I hope I have answered your question. Ms. Eunice Yung. So, the word record. For A and B, they are both referring to acts of creating an image or making an audio record. So the two are referring to the act itself, not the action of recording, is it? In relation to A is an act of creating or generating an image or an audio record. B refers to retention or storage of the record. So B is in relation to retention or storage or otherwise. As just now I referred to streaming. That is transmission in real time. We want to cover both. So these are acts. B is also an act. It's not referring to the act of recording. One is record, one is record. B is also the act of recording. It's not referring to the record. Is in relation to the act of recording. It's clear from the English version, but in Chinese, it may refer to the act of recording or the record itself. B is also the act. It means the act of making an audio record, a visual record, or an audio-visual record, with or without retention or storage. So it refers to the act. Mr. Y. Both A and B refer to the act. In Chinese version, B says include any act of making these record. And towards the end, there is a modifier with or without. That is to clarify whether there is any retention or storage in physical form or electronic form. So both refer to the act. Next, Ms. Doreen Kong. I apologize in advance because there may be many questions in relation to Part 5. The public may be concerned about this. It refers to offenses and penalties. When it comes to image, it means a portrait, a drawing, or a sketch. I understand what drawing and sketch is, but why does it have to differentiate among the three, a portrait, a drawing, or a sketch? Why do you have to add portrait? Because you can draw a portrait or sketch a portrait. Why do you take it out and make it a separate item? B, a photograph, a video record, or film. So what's the difference between these, between the two? We want to make the term image general, covering the different terms in everyday life referring to image. That's our policy intent. Regarding the usage of a particular term, I would defer to Mr. Y. Mr. Y? Ms. Kwok. Well, there is a summary offense ordinance. There are provisions in relation to the making of drawing, sketch, or portrait. Well, when it comes to drawing or sketch, it may cover everything. But regarding the offenses, there are protected persons. They may be witnesses or judges. We think that this reference may be clearer. I think if we use the word portrait, it will be quite specific. That's why we don't want to be stingy when it comes to the use of terms by adding one. Members raised the question. Sometimes we prefer to be general, sometimes we prefer to be specific, and this is our rationale. We need to consider consistency and in this case the offense. So if someone makes a portrait of the judge, then it's an act of making a portrait of a judge. When we frame the charges, it will be more precise. I thank the member for the question so that we have a chance to elaborate. As I said, we take members' comments into account when it comes to drafting. We'll also have a discussion with the policy team to try to strike a balance whilst making the provisions more plain. Ms. Kong. What's the difference of these terms? Video recording or film? Or photographs is a picture photograph. Video recording, in general, is a recording of a video. It can be long or short. For film, we have drawn reference from other ordinances. There is this reference when referring to image. We don't want to be inconsistent. The member's concern is whether there is any duplication. Our answer is maybe. But in drafting, if we use one additional word to eradicate gray area, then we will do so. You see some defining words, the words themselves are similar. We want to make the elements clear when it comes to offenses. We don't want people to argue with us that this is only a video recording. So video recording or film can be different. You may only be making a video recording instead of a film. We don't want people to use the words. Well, this is a new piece of legislation which will form part of the laws of Hong Kong. So whenever we can, we want to make it clear. I thank member for giving us a chance again to explain. Yes, some terms may be general. Sometimes we need a term that is more precise. We try to strike a balance. I'm talking from the perspective of a user. Photographs is easily understood. Video recording, yes. When it comes to films, there are microfilms, micro-productions. Are they included? So, the definition of film, what is it?
成個法定程序。
We think for court proceedings, even if the hearings are remote, they should be respected. When we talk about offenses later, I think members understand why we are putting different terms for the definitions, because we would want to take a higher or lower threshold for one, say, making a film. There may be different ways of people going about committing the offense. And whether the court regards one as having committed an offense, they would refer to the common law and maybe future court cases. But I think we should adopt a broader starting point. I understand what you're saying. You said there may be a potential overlap between the two. I understand why you are making a distinction between video recording and film. But then there are different types of films, right? And in fact, sometimes films actually mean something more than movies. So I want to ask, for films, you're adopting the wide definition, not the narrow definition, right? So you are trying to adopt a broad definition for films, right? Deputy Judiciary Administrator. Thank you, Chair. Indeed, Chair. As the law draftsman said, we are trying to adopt a broad definition to incorporate the general definition of films. We don't want there to be any gray areas. So we are adopting a broad definition for films. Thank you. Clause 26. Please proceed. Clause 26 is quite similar to Clause 27. The drafting is similar also. The difference mainly lies in Clause 26 being about the offenses of recording and publishing protected sessions and protected subjects, whereas Clause 27 would be offenses of recording and publishing broadcast. Let's start with Clause 26. Subclause 1. A person commits an offense if the person, without permission of the court, intentionally records either or both of the following: A protected session of a proceeding, B, a protected subject in relation to a proceeding. Chair, if you allow it, I will skip to the part behind following this, the definition of protected sessions and protected subjects. So for the definition of protected sessions, say in B, in A, in relation to a proceeding that is conducted through a remote medium specified for the proceeding, means the proceeding, and includes the following periods. 1. The period before the start of the proceeding when any of the specified persons is already connected to the remote medium. 2. Any breaks during the proceeding as ordered by the court. And 3. The period after the end of the proceeding when any of the specified persons is still connected to the remote medium. There is a part B, but let me stop here. Part A is about for remote hearings, there are protected sessions. What does that mean? You may have attended some online meetings before. You know, in a way, you have to first connect to the medium. So once you are connected to the medium, for the protected subjects, actually, while we're talking about protected subjects, let's talk about the definition. Protected subjects mean in relation to a proceeding means the courtroom in which the proceeding is conducted and any person appearing in the courtroom. So that would include judges, clerks, or maybe jurors. So in the protected sessions, or during the breaks of the proceeding, or in 3, the period after the end of the proceeding, when the specified persons, say the legal practitioners, say JJOs, jurors, participants in respect of the proceeding are still in court or they are still connected to the remote medium. So we want to prevent the situation for when the specified persons are still on the screen, someone tries to record and publish the screen recording. Mr. Leitong has pressed the request to speak button. I want to ask if his question is about what is said. If it is, I'll let you ask the question. All right. In 26.1, you have talked about how it would apply to, say, protected sessions and protected subjects. So we were discussing protected sessions. So if you have used the expression either or both, why is it necessary? Because if one commits or if one records either of the following, one is already committing an offense. It seems that while you put in the expression of either or both, there should be different penalties, but it's not the case from the future or from the subsequent provisions. So why is there a need to say either or both? Thank you, Deputy Judiciary Administrator. I'll let the law draftsman answer this question. The member's understanding is correct. Either or both of the following is recorded. One is committing an offense. We just want to make sure we catch all of the scenarios where either or both of these are recorded. One would be committing an offense. We again are trying to adopt a broad brush approach here. We try to adopt a broad definition. But the member's understanding is indeed correct. But as said, we have consulted public consultations, and we do understand that there are consequences to the public with these provisions. That's why we have been trying to adopt a broad definition, as the penalties are quite heavy. We want to make clear either or both of the protected sessions or the subjects, protected subjects are recorded. One would be committing an offense. But then, of course, there is a distinction when one is recording a judge or one is recording a juror, but then in the offenses, it should be treated as the same. So we want to make clear either or both. One would be committing an offense. Before we have tried to use either or any of the following, it would be essentially the same. So I want to also ask, in 6.1 you have differentiated, you have separated the different parts. And in here you have not. So can you adopt a more consistent approach so that it would be easier for people to read? Thank you, Deputy Judiciary Administrator. I believe the member is referring to subclauses 2 and 3 of clause 26. We haven't really got to that part, but these are different acts. Subclause 2 is on the publishing of an unauthorized proceeding recording or a reproduction of an unauthorized proceeding recording. For 3, it is that one knows the person has no permission of the court to publish the recording or reproduce the proceeding. So there is the part that the person knows that the person has no permission of the court. My question was on the presentation, because in subclause 2 and 3, they have different treatment from subclause 1. I just think you can adopt a more consistent approach. Deputy Judiciary Administrator, we will review the drafting to see if there's any need to make changes. Thank you. Mr. Y. Mr. Lai's observations are quite acute, and in 26.1, it says, in particular, for some parts of it is included in the lead-in sentence, but for subclauses 2 and 3, as there are parts A and B and the parts are connected. So, say in A, between parts A and B, there is the linking word and. So there is a difference between subclauses 2 and 3 and 1, because in subclause 1 there is a difference of either or both, whereas for subclauses 2 and 3 it has to be and for the two parts. Thank you. Well, it's almost time. I see that Mr. Rincon would like to ask questions as well. I'll let you ask your questions, and I will exercise my discretion to extend the meeting by 15 minutes, but we will end the meeting after Mr. Rincon has asked her questions. Thank you, Chair. I want to ask about protected sessions, the definition. So in A2, it says that it would include the period of breaks during the proceeding as ordered by the court. So with proceeding, we do have a wide definition, and we're talking about the whole proceeding, the whole court proceeding. I would like to see confirmation from the Department of Justice. When you're talking about breaks, are you talking about breaks for a particular hearing? You're not talking about the adjournment, right? Because breaks can mean many things. For like a month-long trial, what does a break mean? Deputy Judiciary Administrator, when we're talking about breaks, we are talking about breaks, a short break during a hearing. When we're talking about proceeding, we would talk about, as said here, the specified persons are already connected to the remote medium. So we're referring to short breaks with the use of the word breaks. And you can see in 3, it would have a condition that specified persons are still connected to the remote medium. So there is this prerequisite here. Mr. Rincon, you have follow-up questions. I think it's very simple because you are just talking about throughout the connection, right? And honestly, with proceedings, it can last for months. So with what you have here in 2, it is somewhat confusing. I do understand what they're saying. I would just like to point out there may be some confusion associated with this. Alright? I guess the administration and Judiciary Administration can review whether we should make clear that the breaks are referring to breaks during the hearing, not for the proceeding. I think we can't complete the scrutiny of Clause 26. We'll continue the scrutiny of Clause 26 at the next meeting. And We will hold the next hearing on 3rd of February, a Wednesday after Chinese New Year. Excuse me, it's not 3rd of February, 5th of February between 9:30 in the morning and 12:30 p.m. All right, I believe there's no other business. If members consider it necessary, you may refer to the relevant annex. So this is the end of the meeting. I wish you all a prosperous new year. Thank you.